Thank you very much, Doug. Hi, everyone. Why are we here? We're here to improve our practice. We're here to get better results for our clients. We want information that's going to help us. So I'm going to try and convey some of that to you right now. Our brief is our first impression to the arbitrator. We want the arbitrator to appreciate those things that we want the arbitrator to notice. So first thing is, your brief's your first impression. Sorry here. Your brief is also your credibility. You're not just presenting facts, but you're being sized up. The way you present your information is just as important as the information itself. Don't misstate the facts. Oftentimes people want to embellish on things. If you'll remember, people like Bob Simon, he goes into trial. First trick that he does is he talks to the court reporter, he gets the transcript from the opening statement, and then at the time of close, he uses that transcript to show the jury all the things that defense counsel promised to show the jury but did not do. That misuse of facts can also come back to bite you in these cases. So you want to put together a brief that's going to have all the facts in it with the evidence directly on it. Another thing that you're going to hear is that arbitrators, you've heard all day, they want economical. They don't want a 500-page deposition. They want the 5 pages that they need. If a client has a surgery and they do a pre-op and they have a lab report with 10 pages of CBC information, they don't need it unless that's relevant to the case. Don't include it. You're paying for their time. You're paying for their expertise. Don't waste it. Give them the stuff they need. Make it easy for the arbitrators to find the information. You, as advocates, are teachers, okay? You want to teach them your case. If you know your case, you can teach it. If you can teach your case, you know it. What you're going to do is you're going to teach people visually. People are visual learners. So when you have a case, you want to give them something that they can see. I do a lot of cases involving autos and premises. One of the visuals that we like to see is the actual premises. You can get this information straight into the brief. If you have what was 1613, now 3.823, you do your 20-day rule disclosure, it gets in, okay? And the information is demonstrative as well. You scan it straight in, or you put it straight in. Now, the tricky thing is, how do you get it from the internet to your computer? Some of you are savvy, some of you aren't. Very briefly, I want to explain how it works. To get an aerial view of any place in the world for free, you go to something called Google Earth, not Google. You actually have to download it onto your computer. Go to Google, type in the words Google Earth, click on the download, click on the agreement, and then you'll get an icon on your computer. Excuse me?
Does it have an arbitration clause?
Oh, it could. I would ask Arthur. Click on that. It'll give you the subject. Then you search for the subject premises. Basically type it in. And you have it on your screen. Now, to get it from your screen into your brief is an issue because it's not a downloadable file. What you have is an image on your screen. Now, for years and years, you've had this print screen button on your keyboard, and I would venture to say probably 80% of you have never used this print screen button on your keyboard. This is what you use it for. Use it to capture the image onto a clipboard so you can dump it into a document. You use these 3 buttons, Control Alt Print Screen, puts it on a clipboard, and then you can right-click onto your mouse, or you can hit Control V, and then you can dump it straight into your document. Also works excellent with PowerPoint. Traffic collision reports. For those of you that handle automobile accidents like I do, traffic collision reports, what's the first thing you look at? You look at the diagram in it. What do you think the arbitrator would appreciate? Having the diagram right there as you're explaining the facts of the accident, especially when there's a complicated set of facts. One way to do this is to use a scanner. I use a desktop scanner. It's at Costco. It's about $400. It's a flat top scanner. Basically, you just lay the document flat, press the appropriate buttons, and you end up with a JPEG file, which is essentially the same kind of file as you get from your cameras. You can then take that JPEG file and dump it into your word processor, and then you have the traffic collision report image straight in there. Arbitrator gets your point. They start seeing where the moving parts are. Put point of view images into briefs, point of view images of drivers especially. Again, go to Google Maps. Google Maps, type in the street, you can see unimpeded views of where people are going. Put that in there. You can see that the person operating the vehicle either had a point of view that they could see or not see what was coming. Do the same thing we did last time. You go to the image. How do you go to the image? Google Maps. Click on Street View. Type in the intersection. Pick the street view that you want. There it is. Use, again, that combination of Control, Alternate, and that print screen button. You've captured it onto a clipboard, and it is now ready to be put into your brief. Property damage photos. Property damage photos are good to put right up front, especially if they're dramatic. It gives the arbitrator an appreciation for what the person went through. A lot of times we have a tendency to say, plaintiff's vehicle was a total loss. Okay, the vehicle was a total loss, but that doesn't really give any sort of energy. There's no emoting. We all emote. We want the arbitrator to emote about what's going on. You put a photograph of a dramatic property damage, and you say, "Dear God, how did this person survive the collision? What can I do in my position, in this case, to do the right thing for this person?" Okay? Unlike the JCJI, where emotions, not even you're supposed to be admonishing people about emotion, arbitrator, professional, they don't need that admonition, but they do need to understand what the harms and losses are, and this is one way to do it. Put this right in the forefront. Don't bury it inside a trial notebook. Make sure they see it right off the bat. So now, while they're reading your brief, they have in the back of their mind the seriousness, the gravity of what they're dealing with, what your client's been dealing with for years before they got there. When you have multiple parties in a vehicle and the damage is a little different as to where they are, you can put into your photograph through a word processor as well, seating. Identify where they are, shows the magnitude, why one person in the back seat is more seriously injured than someone in the front seat, where there's intrusion in the vehicle. Bodily injury photos. Does this work? Yes. Great. I appreciate that. Thank you. Bodily injury photos. Bodily injury photos are very important for personal injury cases. A bodily injury photo is going to give the arbitrator the information right at their fingertips. Now compare again. In your brief, you simply say, plaintiff had a surgical scar. Instead, you can show the surgical scar and talk about how this person feels about it. Single woman has very much self-conscious feelings about it. It's a big, big damage. Much more powerful for the arbitrator to see it right off the bat than try and dig it up. It's contemporaneous with the information they're reading. It helps them to get your point as you're making it in your text to see it at the same time. This next image is a bit rough. This is a hand injury case. If you don't like rough images, just turn away in a second. But this one, basically, if you say this person has significant hand injury, or you can put straight into the brief, the gravity of a life-changing injury. As the arbitrator sees this, this isn't just an ordinary damage case. This is a big deal. I want to continue to learn more about what happened to this particular person as they read it. This is your opening statement. Because the facts are contained in there with the evidence, you're not going to overstate things you can't mess up later on where the defense is saying, well, they said they were going to show this. They did say it, they did show it, the evidence is right there, and we followed a roadmap all the way through. Explain injuries with diagnostic imaging. If you don't have the diagnostic imaging, you can't show it. Order copies of CTs, X-rays, MRIs, and once you get them, put them into your computer and look at them. If you don't know what you're looking at, Google it, go to Wikipedia, contact a radiologist, get somebody, pay him $300, or go to the guy who actually read it and learn how to read these things. If you're personal injury attorneys, I would like you guys to be able to understand what it is you're trying to convey so that you can do a better job when you're trying to explain it to the other side and the arbitrator. In my case, I have a client with a facial fracture. Saying a facial fracture isn't as strong as showing a 3D CT scan of a Lefort 3 fracture, which basically is a break here, a break here, a break here, all the way through the skull, where the face is now in two pieces. This person should not be alive. Much, much more powerful for the arbitrator to read that as they're going through your brief, to see this image that by the grace of God, this person's still on the earth. As they're reading the medicals, they want to know more. Crushed orbital, I want to know more. Broken teeth, I want to know more. Learn how to read MRIs that are different than just CTs. For example, this is a meniscus case. My client had a torn meniscus. What we did was we got an exemplar of a healthy meniscus. As you can see, the meniscus here between the femur and the tibia plateau, the meniscus is solid black. That's a healthy meniscus. What do we have in our case? We have a meniscus with fraying. You've got lines of gray and black in there. You've now learned how to read it. You've taught it to the arbitrator. The arbitrator knows how to do it. It's visual learning. This visual learning is irrefutable. You've proven your meniscal tear. Explain with diagrams what you're dealing with. Here, what's the meniscus? It's between the femur, the tibia. It's the cushion. It's the cartilage. This is the part of the body we're talking about that was injured. Explain it to the arbitrator. Make their lives easier. You guys like easier lives, correct? Okay. Continue. Visual learning. How many people have handled a spine injury? Please. How many people have handled a spine injury? Okay. Know how to look at a spine MRI. In this particular case, the defense said that the radiologist misread the MRI and there was no injury. So what did we do? We went to the radiologist. We asked the radiologist to show us where's the injury. Radiologist gave us an MRI of a healthy spine, gave us an MRI of our client's spine, and showed me what I was looking at. So what I did was I took that information, I scanned the impression of the radiologist, which states total occlusion of the spine at L4, L5, had her show me where the discs are for L1 through S1, and this is the occlusion right here. Okay? Irrefutable. You've taught your arbitrator through visual learning. Their defense expert has no credibility anymore because the arbitrator not only has the evidence, but you've taught them how to interpret it. Use demonstratives for surgeries. You don't have to show your client's own surgery, but you can show how a surgery is done. This particular case was an ACL replacement. This ACL replacement involves the removal of the anterior cruciate ligament, the biggest ligament in the knee, from a cadaver and then fabricated into a workable piece, attached to some bolts, and then inserted into a healthy knee with drills. That is a big deal surgery versus client had ACL replacement. This is teaching your arbitrator. Now, your arbitrators may have the medical background. They may have even had these personal surgeries. It could be a different surgery. Not everyone's going to know everything medically, but get yourself up to speed on the procedure that your client has had and explain it to your arbitrator just as though it was you were teaching someone that has no background in it. In your medical records themselves, there will be diagrams either filled out by the client or the doctor. Put them right in there. When they try and say, your client never complained of back pain, well, actually, right here, Your Honor, in the notes that were taken the first week, you can see back pain is actually on the diagram. Okay? Also, how do you interpret this information? A lot of times people see range of motion, or they'll see certain tests. How do you interpret that? Well, it's helpful if you take this data and you put it to actual use. That is range of motion information. What I did was I took photos from a medical book of range of motion that's actually conducted, and then I put the measurements that were observed by the doctor, compared them to what normal measurements are, and then I put a percentage of limitation on there. I don't know if you can see it too clearly on there, but there's percentages of limitations and what the limitations are caused by. They're caused by pain. You can't see pain, you can only see indicia of pain. You can't look at it on a monitor. You can't look at it on a screen. You can only look at it by the way the person acts or objective findings. One of the things that you can also do, which isn't in part of brief writing, but collect your client's pill bottles from the very first day of their injury. Keep them in your office. Every empty pill bottle is there as an indicator of pain. We had a case where we filled up a Rubbermaid container, a plastic container, the size of a bathtub with empty pill bottles that this person took for pain. 7-figure case. Explain the objective testing that's done on your client. What is this test? It's a McMurray. It teaches us to confirm or correlate subjective findings. Well, okay, he had a McMurray. Well, Your Honor, a McMurray is done by turning the leg, and if you have a sound or a palpable feeling in it, then you have a McMurray. It's an objective finding. Okay? Explain how they get that so that the arbitrator understands more about what you're trying to present. We are visual learners. Be visual teachers. Compression test. How's it done? Explain it to your arbitrator. These are objective findings correlating subjective complaints of pain that people cannot otherwise see. Now, yeah, that's not my client in the photo, but it is a real process of a real examination. Arbitrator can now determine whether or not there's more weight to your position based on the fact that they know more about the testing. Take the diagnoses straight out of the records. Put it right where you're talking about it. Doctor's opinion was X. Here's the record that says that. There's no misstating of the facts. Your Honor, this was the particular injury. Also, if you have a chiropractor claim where there's treatment and diagnostic, you know what? Explain the cost per treatment to the arbitrator. A lot of times they just want the bottom line. Was it $300 a visit or was it $125 a visit? That way they can more quickly and more accurately find what it is that you're asking them to find. Mechanisms of injuries. This is a little bit more complicated. I actually developed this by using some biomechanical stuff that I got from an online service. And this is admissible if you have a doctor that has some biomechanical background. Very simple. Most orthos take biomechanics as part of their regimen in school. You can back this up, but this also explains when they say, well, you know, it was just a tapping of the bumper. Well, that tapping of the bumper in the blink of an eye created a lifetime of consequences. So with that in mind, I'm going to tell you guys, I have 10 sample briefs on these chips here. They're actually USB drives, and they've got some really broad examples of things you can put into your briefs, including some good damage explanations when you have DUIs, how to treat DUIs, and so forth. I'm going to ask Daniel, my good friend here, to hand them out to you. You can also get this information. We just put up a website so you can pull it off writebetterbriefs.com, so you can grab it off there as well. Thank you. It's been my privilege. I'm honored to be among these folks. Thank you for your time.